So, very good evening to all of you. So, today we are going to discuss one of the very interesting issue relating to the forensic. So, normally what happens when the forensic results are being exhibited in the court? So, when we see in number of cases, either there is no cross-examination, or sometimes we find that the cross-examination is not up to mark or not on the proper line. And even in few cases, I have seen that the cross-examination which is done is not relevant one. So here we are going to discuss what should be the line of cross-examination. And in order to decide that what should be the line of cross-examination, we should know what the expert need to comply with. So here we are going to discuss what are the essential requirements of a person to be a forensic expert, how to decide about his competency, how to decide about credibility of the report, what are the things which are required to make the report admissible, and what are the things which are required to be looked into for determining the authenticity of the report. And you see, if we look upon the practical scenario which is in the code, we always find that in a large number of cases there is no cross-examination. In one of the case which I will share with you is that when I start doing the cross-examination of an expert asks you whether you will also do the cross-examination. So, well, that is the scenario. But how will you meet the challenge if the forensic report is incorrect? You know that it is incorrect, but how you will do the cross examination to bring the truth on report? And I tell you that if we go by the international standard, there are very high level of standards for the principle or the issues which are required to be looked into for the purpose of reliability. For example, one of the very prominent issue which is always being looked for in the forensic report is the compliance of the standard operating procedure. So I give you a very simple example. Let us take if it is a forensic relating to the digital forensic. Now the person who is going to appreciate, the judge of the court, whether he is an expert, no. Whether he would be able to determine what the expert has done, the method he has followed, the principle he has relied upon is correct or not? No. Then how is going to decide about whether the examination which has been done by the expert is up to mark or not? So the answer is he cannot do. And the only way to determine it is by analyzing whether the expert has adopted the standard operating procedure. So that means standard operating procedure should be something which should allow the expert to do the examination in a objective manner, in a independent manner, in keeping in view the interest of both the parties, the party who is a complainant, party who is an accused. So what he need to do, he need to bring similarities as well as the dissimilarities both on record. Then he should give a finding whether the what is his opinion and what are the reasons for the opinion. Just let me share my PPT on this on the topic. So in this present episode, we are only going to discuss more about the digital forensic, but I would be covering the basic principle which are required to be looked into the expert testimony, expert report, or expert evidence. So, first of all, let us understand what is the expert evidence. Like any other type of evidence, it is an evidence which is being perceived by an expert by his senses. So that means what he has actually observed using his own senses, that what is written in section 60 of the Evidence Act, or in any other manner. Any other manner means by doing some forensic examination, doing using the tool or using the technology. So there are two components. One, the fact which is perceived by senses. Second is the fact which is derived by using any scientific method or tool. Okay.
Yes.
Second is the another approach to look into the expert evidence is that expert evidence has two components. One is the data evidence, second is the opinion evidence. So what is the data evidence? The actual data which is either retrieved, analyzed, or collected by an expert to form the opinion. So that means in any expert evidence or in any expert report, there may be both the thing. There may be data evidence as well as opinion evidence, and there may be only the data evidence. So, for example, I give you an example that if the task of an expert is to recover the data from the hard disk or the pen drive, so what his report would be that he has recovered this data, but there would be no opinion. That is the first component. Second component is that a data has been provided to the expert and expert has been told to give the opinion. So in that particular case, the expert would have the data, he will analyze the data and then he will give the opinion. For example, when you give a video to an expert, he will analyze the video, he will look into the authenticity of the video, then he will give the opinion whether it is genuine or authentic, so whatever is required. So in some cases it would be the only data evidence, in some cases it would be both. But the very important principle which we need to understand is that when the issue is before the court to drive the truth regarding what is correct and what is incorrect, it is basically the function of the court. So when the expert is doing analysis to drive whether it is truth or not, he is only doing to give an advice to the court because basically it is the duty of the court, it is the function of the court, it is the power of the court, and court cannot delegate its own power. So ultimately, role is of the court to determine what is true or not, and the role of the expert is only to give the advice to the court. So basically, that's why we need to look that the function of the expert is to give the entire fact. Then what analysis he has done and what is the opinion which he has formed. So basically, there would be three components: the fact, then analysis, and then with the opinion. And all these three should connect with each other. So that is the exact role of the expert. So expert is opinion is not conclusive, only of advisory nature, which would assist the court in forming an opinion, and ultimate driver would be the court only. So that's the perspective. So that's why whenever there is any expert report which is being exhibited in court in any of the forensic examination, so that would be treated as similar to the any other evidence, not more than that. Now coming to who is the expert. So basically that is not defined under section 45 of the Evidence Act, but that has been defined in the number of judgment. So let us take an example of a CCTV evidence. So if we talk about the CCTV evidence, then who would be an expert regarding the CCTV evidence? So first thing is he should have the educational background in the relevant field. So that means he should have some educational background knowledge regarding the CCTV evidence. Number two, practical knowledge in the relevant field, in the same field. So he should have certain understanding about how CCTV works, how it maintains the data, how it generates the data, how to authenticate the CCTV evidence. So that is the second. Third is the analysis. So what analysis he is doing. So that's very important because here when we talk about the analysis, so analysis means the analysis should be done with the objective approach, with the approach of independence. So here what the problem comes, for example, when the exhibit are being sent from the police or from any other organization, so normally they also send the brief act. And you will see in the brief act, the police normally write down the what is the background. So this is, for example, it is a case of murder and murder has been committed so, and this at the spot this person has been apprehended, and that particular hard disk or any other exhibit have been recovered. So what happens? Because when such a material is being sent, it tried to prejudice the mind of the expert. But when expert do the analysis, his analysis should be in objective manner. Number one, to see whether the evidence connect it with the accused or the particular fact. That is the one thing. Second, whether it rule out the possibility. That means it may have been done by some other person, or whether it result into the negative finding. So that would be the objective approach. So whenever we do the cross examination, so the best way in the cross examination is for from the opposite side, from the while doing the cross examination of expert, we should first make out the point which the expert has not done, which he should have done. Or in other way, so I give you another example. Take the example of a video evidence. So in one of the case of the video evidence, the what the expert did, he extracted the frame, and on the basis of the frame, he has given opinion that there is no tampering into the said video. But when we ask him the question that whether you have determined what is the resolution or what is the frame rate per second of this particular video, and whether you have compared it with the source, his answer is no. So that means he should compute the resolution, and if you compute the frame rate per second, and if it does not matches with the source, so that means that evidence has not come from that source. So here the careful analysis means the analysis should be done in objective manner. It should follow a standard procedure, that is the SOP. And after that, even if the expert has done the forensic examination using any tool, that is not sufficient. He need to explain the technology, the objective underlying that technology, how using that technology they are going to prove a particular scientific principle, and thereafter whatever conclusion he has given. So he has to connect these three things very beautifully. Number one, what is the fact, what is the analysis, and what is the opinion. All these three things should be connected. As for the analysis, he need to prove, he need to explain why he has done a proper that particular analysis, and why he has not done some other analysis which he need to do. And regarding the opinion, he need to connect the opinion with the analysis. He need to connect the opinion with the fact. So basically, all the three components should be very well explained by the expert. So definition of the expert. So expert have been defined in a various way by the various high courts. For example, Delhi High Court in the judgment of Siddharth versus State have stated that expert is only an expert if he follow the well accepted guidelines to arrive at a conclusion and support the same with logical reasoning. So here, one of the essential requirements which the court have stated is that experts should follow the well accepted guidelines, for example, standard operating procedure. So that's why whenever you are going for cross-examination of an expert, before the cross-examination, you must file an application before the court that please give us the SOP, so that you can see what the SOP says, whether the expert has followed the same procedure or not. So you can compare them, and accordingly you can do your cross-examination. So in another judgment, the High Court of Himachal Pradesh has observed that in order to bring the evidence of a witness as that of an expert, so when the evidence would be of an expert, it has to be shown that he has a special study of the subject or has acquired a special experience therein. So here one of the big gaps which you will see in the report which is coming from the forensic FSL or the CFSL, that in one of my case where the report have been given by the regarding the computer forensic, and in the last when the expert have signed in the in his designation he has written the chemical forensic expert. So now the issue is how the chemical forensic expert can give a report of digital forensic. So when we ask the question in the cross examination, he has stated that he is a chemical forensic expert, but he has been posted in a digital forensic lab. So in such case, where the person does not have the educational background, does not have the training, does not have the skill into that particular field, he is not competent to give an opinion, and this would be the only ground to reject his forensic report. So that's why we need to put the entire effort to see whether he meets the required criteria, which is for an expert to be a competent expert. So the third in one of the another very famous judgment, Champor Singh versus Mithu Singh, the court has stated that where the court has to form an opinion upon a point of foreign law or a science or an art or has to the identity of handwriting or finger impression, the opinion upon that point of person specifically skilled in such foreign law, science or art or in question as to the identity of handwriting or fingerprint are relevant facts. So this is basically the section 45 of the Evidence Act. So section 45 of the Evidence Act on the face of it does not explain what is the qualification. But there are a number of judgments where the qualification of the expert have been uh, given, that what should be the qualification. Second is the competency. So qualification and competency are both at one and the same thing. So in order to see whether the expert is competent or not, we need to see whether he is qualified or not. So the same four things which we have observed regarding the requirement of the educational qualification are the same which is required for the competency of the expert. So I have referred to the two judgments where the High Court have held that these are the factors which are required to be looked into to find out the competency of the expert. Now come to the credibility of the expert. So one thing is that the expert is now competent. He is a qualified person. But whether he is a credible one, so how you will determine what is the credibility of a particular expert. So depending upon the various factors, an expert may have a high credibility, an expert may have a low credibility. So here the important thing is I am talking about the credibility of an expert, not of the forensic report. So in the judgment of Naveen Krishan Moti Reddy versus State of Telangana and others, the High Court has held that the test to determine the credibility is the basis of opinion. So basically, the connectivity which is between the fact, analysis, and the opinion. So the explanation of that connectivity and how the expert need to explain. Expert will explain that what is the technology which he has used and how he has arrived at the particular opinion. So that would be basically the reason. What are the reason on the basis of which he has derived the opinion? So normally if you will go by the various forensic reports which are being filed in the court, you will see that in a large number of cases the specific reason of the opinion are not given. So there during the cross-examination, first the test which you need to follow is you need to segregate your forensic report into three components. What is the fact? So you need to see whether the fact which has been observed by the expert are correct or not. Second, whether that fact or the data, if we talk about the electronic evidence, where data is admissible or not. For example, if the data is not admissible and the forensic has been done and even if the opinion has been given, then it cannot be looked into by the court. It is not admissible at all. So that has been specified by the Supreme Court in the judgment of Anwar P. So now, once you are satisfied about the fact, then you need to see what is the analysis and what is the opinion and to what extent all the three are connected to each other and whatever the explanation which is given by the expert, whether it is logical or not. For example, if the expert says, let us take an example of a video forensic which has been done by an expert and now expert has given the opinion that this video evidence is authentic, right? So what do you mean by authenticity? Authenticity has the two components. Authenticity has the two components, that is one is source and second is the genuineness. Now, expert, for example, if the expert has done only the frame by frame analysis or some other test but have not done the determination of the source, then you can always put a question, can you tell how you have connected or how you have proved the source of this video evidence? And if he has not done so, that means he may have given an opinion, but that is not based on the sound reasons, right? So that connectivity will determine the credibility of the expert. So that means whether the expert is in a position to corroborate his opinion by the sound reasons. Next is the admissibility of the forensic report. So when now we are not talking about the admissibility of the electronic evidence, we are talking about the admissibility of the forensic report. So in the judgment of the Ramesh Chandra Agarwal versus Regency Hospital, a very famous judgment given by the Supreme Court has laid down a test how to determine the admissibility of expert evidence. And the very important thing which you need to keep in mind that if you are able to break either one of the element out of these four, the expert report itself would not be admissible. Left apart the other things, left apart the reasoning and the opinion. So first is he should be a qualified person. His expertise should be from the recognized field of expertise, right? Third, his evidence must be based on the reliable principle. So reliable principle means one, the standard operating procedure, second, whatever technology he is using, and then whether that technology is reliable or not. So how the technology would be reliable or not. So there is another test to determine that will come in the subsequent slide. Then would be whether the scientific question. Now this is very important thing. In the beginning, we have discussed that the report of an expert is of advisory nature and to support the opinion, support the court informing an opinion. But why the court will look into the opinion of an expert? So, for example, if there are certain facts from which the court can make the opinion itself, then court will not look into the expert evidence. So that is the first and the basic principle. Because the court is not going to delegate its own function of determining the truth. So these are the four factors which are required to be looked into while determining the admissibility of a expert evidence. Now, so I give you another example how we have dealt with this issue. So there was a case of the video forensic, and in the video forensic, we did the cross examination regarding the encoding date and time. So first, coming to what is the encoding date and time. So whenever you capture any video, the moment you save the video, you will see it take a fraction of second, and you can always see that it is going to be saved. So basically, that particular exercise, that particular process is called as a encoding. So whenever you create a video, the moment you preserve that video, it does encoding, and that encoding date is preserved in every video. So that encoding date is the best example when that particular video is actually created. So when the encoding date will change, now you have created one video, its encoding date is preserved. Now you alter the video, you cut the video, you reduce its size, you edit it. So in any way you alter it, its encoding date will change. For example, if I have created one video on first of a month, and after 1 week I do some change, so its encoding date will change. So it would be the subsequent date. It would be the date of edit. So now what happened in this case, in the case where we were doing the cross examination, is in that particular case the FIR says that the PW recorded the video on 28th February 2010. So this was the case of the prosecution that the witness has created the video on 28th February 2010. But when we analyze the encoding date using the EXIF data, the metadata of the file shows that the encoding was done on 5th March 2010. So after a week. So that means the encoding date was not a date of original creation. The encoding date was a date which was different from the date of original creation of that video. So it leads us to the irrebuttable presumption that it has been altered subsequently. Now what happens when we have asked that question to the expert? Now my question to the expert was, can you tell as to what is the meaning of encoding in case of a video file? So the answer of the expert was no. Now the very important question is, a person who claims himself to be a video forensic expert coming from a reputed CFSL with a experience of more than 20 years, and he gives an answer that I do not know what the encoding is, which is something which is very basic to every video file, every audio file, right? Can we term such an expert as a forensic expert? So basically, my answer is no. So we should always look into what are the issue relating to that particular forensic examination, and we should ask the question to the expert if he has not conducted a proper type of examination. And there are two way of asking is number one, what are the technique of that cross examination technique of that examination. So for example, in case of encoding, so first is what the encoding is, whether he know. Second is whether he has done that exit data analysis to determine whether the encoding date matches or not. So there are two components. So if from the first component, even if the expert says even that basically does not know what is the encoding, so that means the possibility of doing the examination is ruled out. And again, if the expert says that he has done the forensic examination, we must ask for the report or the data which may be available in the internal worksheet. So now this is another case where we were able to convince to the court that the expert is not a competent one. So here the case was of the forensic examination of a hard disk in the of the CCTV. So when we do the cross examination of an expert, what is his qualification as to the in the field of the forensic? So he was not having any specific qualification in the field of forensic. He has only done a certification which is CHMI, right? Then we have asked him about whether he has any training, practical exposure in the field of the CCTV forensic. Again, his answer was that he did not have any experience in the field of the CCTV forensic. Then we have asked about whether you have any specific qualification as far as the CCTV forensic is concerned. Again, his answer was no. Then the interesting thing which we have got during the cross examination is that he has not followed the reliable principle or the basic principle which are being followed in the computer forensic examination. For example, when we ask him when you receive the original hard disk from the police, whether you have computed the hash value. So his answer was he has not computed the hash value. Then our second question was that before doing the forensic, whether you have prepared any mirror image or whether you have done on the forensic on the original. And the interesting part was that he has not prepared any mirror image, and in fact he has done the forensic on the original hard disk. So which is against the basic principle of the computer forensic, which says that no forensic examination should be done on the original media. Then what happened? During trial, the court directed that particular expert to supply the clone copy of the hard disk. Now, in this particular case, the size of the hard disk was 4 terabyte. So he has prepared a mirror image and he has given us the mirror image. But when we analyze that hard disk of 4 TB, we find that it contains the data which is equivalent to the 1.6 TB. And the reason which we analyzed and which we were able to find why it does not contain the full data of 4 TB but only of 1.6 TB is that because he has used a write blocker with 32-bit addressing, and write blocker with 32-bit addressing allows the maximum size of the file to be created is 1.6 TB and not more than that. And further, during cross-examination, he has also stated that he has not computed the hash value either of the source hard disk or of the destination hard disk. So there were, first, he was not having any qualification. Second, he has not followed the basic principle of the forensic examination. So then we were able to convince to the court that the expert is not a competent expert. Now coming to the another thing which we need to keep in mind is that what is the level of authenticity an expert has to maintain regarding the evidence. So in case of the criminal cases, the burden which is on the defense is only to show the possibility of tampering and not the actual tampering. So that is the standard which is required. So here one of the judgment of the Supreme Court which I want to show how the court are evaluating that particular burden which is to be discharged by the defense. So it was basically a case of murder. And in case of the murder, the fingerprint were found on the brass jug in the house. Where the murder took place, they found a jug on which there was the fingerprint. And that jug was sent to the forensic lab after about 4 days. And the print and the accused fingerprint out was taken and was sent after a period of 1 month. So when the printout was taken from the accused, it was not clear. It was taken again and again. So it was taken twice. And so basically the question which has come before the Supreme Court in this particular case is that whether during all these exercises, whether the chain of custody of the exhibit have been maintained or whether there is any possibility of tampering. So just observing the procedure which is being adopted of taking the fingerprint again and again, Supreme Court has observed tampering is not ruled out. And the another issue which was there was that the fingerprint was not taken as per order of the magistrate and only on this ground, despite the fact that fingerprint matches with the fingerprint on the brass jug, the Supreme Court acquitted the accused. So that's why the chain of custody of that particular evidence is a very important thing. So whenever you come across any forensic report, you must see whether the chain of custody have been properly maintained or not, and you need to do the cross-examination of that on the chain of custody of that evidence from the moment it comes into the possession of the police to the moment it comes or being presented before the court of law. Now coming to the SOP. So in the beginning I have discussed you that neither a judge, neither the lawyer from the opposite side. For example, if I am a defense lawyer on the opposite side, right, or you are a defense lawyer on the opposite side, you may not be aware about the technicalities which have been which are related to the particular forensic examination. So, if you get a report, can you say as a lawyer that the proper procedure is followed? You cannot say because you do not deal with that technology. You are not expert of that technology. Neither the judge can say. So that means how the judge, how the counsel which are in the court will examine, will see whether the proper procedure had been followed or not. So the only method is to by comparing it with the standard operating procedure. But what if there is no standard operating procedure? That is the one thing. Or second, if the SOP is not the up to date or not the proper one. So first thing is it will give rise to the cognitive bias. So that means, so one example I have already given you, that in one of the forensic report, the video clips were sent to the forensic expert, and just by doing that frame by frame analysis, he has given opinion that there is no tampering, right? So, but that may not be sufficient for the purpose of authenticity. So when, for example, if there is in the report it is mentioned that it has been created using the iPhone, so then the expert should have matched the frame rate per second and also the resolution with the frame rate per second and the resolution existing in the mobile phone to give a conclusion that this particular video has been created from the iPhone. So basically then such type of reports lacks the objectivity. It lacks the credibility and court may not rely upon it. So then that means if you look upon the forensic report, it may appear to be valid. But since all the procedures, all the methods or technique which are required to be adopted to determine the similarities as well as the dissimilarities, to see the fact which goes in favor of the opinion or the fact which goes against the opinion, no prudent person can make a logical conclusion out of it. And thus, even the court may not be able to draw the logical conclusion out of such material. So that's why a proper SOP is very important. It should not, proper means that it should be for a particular type of the examination and it should be relevant to the kind of the conclusion which is given. Now let us come to this. This is one of the cases where we have done the cross-examination, and you can see in this the image that there is a video, right? So basically, this is the video frame you can see, and the interesting part is that within the that particular frame, you can see the VLC bar, and you can also see the mouse there. So what does it mean? If you see this thing within the video, so it clearly means that it is not a original video, but it is a re-recorded video. Now, if when we extracted the frame, interesting thing which we were able to see in the frame is that this frame has a border which is unequal. So unequal means that the border on all the four sides should be the same. So you can extract the border in frame in any case of the in any of the video, you will see that this particular frame is always equal. So the frame is unequal, and the another thing is that we are able to see that this cursor and the VLC bar inside the video gives us a conclusive opinion that it is not a original video but a re-recorded video. So now the question which I have asked to the expert is it correct that when I ask about this particular video, the reply which is given by the expert it is correct that I have given opinion regarding the tampering editing on the basis of the cursor and VLC bar which is reflected inside the video. The cursor reflected in the mid video means that it is a re-recording one. He has admitted. Now see the second question which is important. How would you have detected the re-recording? So now my question is that in this case you are able to see the cursor and you are able to see the VLC bar inside the video. But how would you have detected the re-recording if the cursor would not have been moved by the person? So that means if there would be no VLC bar, if there would be no cursor, how you would have detected? The answer was it cannot be detected because we do not have the original source for the comparison of file. But the interesting part is that in this particular DVD there were 11 videos, and in one video there was a cursor. He has a given opinion that it is tempered. In the another 10 videos there was no cursor, but other metadata exactly match. So the exit data, that way it is created, its resolution, its frame rate per second, all other parameter exactly matches. So that means it clearly shows that the other 10 videos have been created in the same manner, but the VLC bar or the cursor, because the cursor have not moved, that have not been captured. But that lead to the clear opinion that the other 10 videos are also forged because the metadata of all the 11 matches. But the expert was failed to give that opinion. So his findings were not connected with, were not properly synced with the analysis which he has done. Now coming to the validity of the scientific technology. So that means if you are using some technology for analysis, so that does not mean that your opinion is correct. Still you use the same technology, still your opinion may be incorrect, may not qualify with the Daubert principle. Right? So what is the Daubert principle? Now it has been upheld in the various judgment of our high courts and also by the Supreme Court in the judgment of Srimati Selvi and another versus state of Karnataka. So in order to find out whether it complies with the Daubert principle, 4 tests are required to be done. So first, what is the first test? Whether the theory or the technique in the question has been tested. If yes, what are the test results? What is the potential error rate? Whether it has been subjected to peer review publication. If yes, whether it has been accepted by the scientific community. So these are the tests which are required to comply in order to qualify whether the technology is valid or not. And the very interesting part is, under this test, which is being followed not only in India but across the world, the court is the gatekeeper. So that means the prosecution has to convince to the court that these 4 compliance have been done and it complies with the Daubert principle. And ultimately, gatekeeper is the court. So that means the court will decide whether the technology qualifies the Daubert principle or not. So now we have one of the case, a very interesting case. The case is of the murder. And when the murder was committed, So they have found that the chloroform was used in committing the murder. So, in order to find the corroborating material regarding the chloroform, they seize the computer of the accused. They analyze the computer of the accused to see what are the other evidences which are there into the computer, and they were able to find that the accused have searched for the word chloroform 84 times, and that analysis have been done using a tool net analysis. But during the cross examination, the defense has come with another tool which is cashback, and using the cashback, it shows that it has been chloroform have been accessed only 3 times. So then court asked that using the same technology by two different tools, there are two different findings. One tool shows that the chloroform have been accessed 84 times. Second tool shows that the chloroform have been accessed 3 times. So they asked the prosecution forensic expert to bridge that gap. And forensic expert was not able to bridge that gap, and then the court has held that the technology does not qualify with the Daubert principle. So that means even if the examination has been done by using a tool, it may not qualify with Daubert principle. Then come to the another thing, that when a report is given by an expert, what the report need to include. So one of the malpractice, one of the wrong practice which is being followed by the prosecution is that when they forward the report in the court, they only give the brief of that particular examination which have been done or ultimate final conclusion. And in most of the cases, these are not supported by the test report. For example, if in case of a computer forensic, if it has been done by using a tool and case, then and case tool itself gives its own report which is in a proper format. Now, you will see there is a practice in the court that they will do the forensic examination, they will write, they will do the case, then they will say that this is the outcome. But they are not attaching what is the report of the case. How they are would be able to convince to the court that actually they have used the case? That is the first part. Or when they have used the case, what is the report of the outcome which is given by the that particular tool, and that report always comes in the form of a document, and that is one of the essential requirements, because in absence of the same, if there is no evidence of actually whether the test has been done, number one, and what is the result of that test, they cannot able to convince to the court whether they have done actually any test or whether there was any such outcome. So that is one of the essential requirements. So in this judgment of Suleiman Usman Memon versus State of Gujarat, the court has stated that such a report has no value until you accompany the test report to convince the court that actually these are the result, these are the outcome of a particular forensic examination. Now coming to the opinion of the expert and the negative finding. So initially we were discussing about the objectivity. So basically the best opinion is where an test is being conducted in an independent manner, in an objective manner. So what do you mean by independent manner? Independent manner means first, without any bias on the mind that whatever is case of the prosecution, that is correct or not. So that is the first part. Second, whenever you are doing a examination, you must look for the similarities, you must look for the dissimilarities. So before the court, there should be the material which should support the finding from the angle of whether that particular fact is true or not. So that means both sides of fact are there. For example, if we discuss about the forensic of a video, so then if the video forensic has been done, then the expert, when giving that the frame analysis so and so, should also find out the other thing to connect it with the source. So, for example, if the prosecution has sent the video that it is created from iPhone, he should not take that as a gospel truth. He should find out whether actually it has been created from an iPhone or not. For example, in this particular case, which we have discussed with you, the case of the prosecution was that it is created using the iPhone. But when we analyze the frame rate, so its frame rate per second was 25. And the frame rate per second of that particular iPhone 5S is 30 frames per second. And even the resolution is also different. Even from that particular evidence, it is very easy for any person, even for a lawyer, by using the simple process to conclude that it has not been created using the iPhone. Now coming to the testimony of the expert, when he give a deposition, but it should include. So the simple approach is that the expert should not directly come to the conclusion. First, he should explain what are the facts, how he come across the facts, and if there are certain new facts which emerge during the forensic examination or analysis, then he should make a deposition regarding how the facts are proved, how he ascertained the authenticity of the fact. Then how he led to a particular opinion or the conclusion, and what were the ground of that particular opinion, and what were the scientific technology which have been used to test the accuracy of these grounds. So that should be the part of testimony of the expert. Simply saying that he has done this forensic and this is the opinion, that is not sufficient. So basically what he has to do, he has to first prove the existence of fact. In some cases, he may have received directly the fact from the forwarding agency. For example, if it's sent by the police, so he can simply say that these are the facts which he has received. Then he has to connect it with that particular analysis, and then he has to connect it with the opinion. Another thing which we need to keep in mind, and this particular judgment of M. Ramesh Babu versus M. Sridhar, very beautifully the Supreme Court has clarified that expert is not any privileged witness. It's like any ordinary witness. His opinion should not be considered as a gospel truth, because even any human can make an error, right? And again, it depends upon the knowledge, it depends upon the education, it depends on the experience of an expert, right? And particularly in this era of technology, when we talk about the computer forensic, right? Younger generation may have a better knowledge to make interpretation than the person who has not the skill, who does not have the education or skill up to date, right? So the testimony of an expert should be considered like any other witness. He should make a proper deposition, he should prove the facts, he should prove his conclusion, he should give the reason, he should connect the reason with the conclusion, he should also prove the technology which he has used for that particular forensic analysis. As an expert or as a lawyer, when you are on the opposite side, you should also adopt this approach to make your cross-examination not only on the fact, not only an analysis, conclusion, but also on the validity of that technology. And we have discussed, for the purpose of validity of technology, we need to see whether it complies with the Daubert principle or not. Biasness of an expert. This is another issue which has come before the court in large number of cases. The first thing is, as I've discussed in the beginning, that when an expert receives the facts from the agency who is sending, for example, if the police is sending that this person has committed the murder, he has been caught on hand and caught on the spot, and this one particular object has been recovered from him. So that normally gives a biasness of that biasness in the mind of an expert. And in case of the private examination, when a particular person hires an expert, that in that case the expert knows it beforehand that why he has been called and what the party calling him wish to be proved. So it creates an unconscious bias in favor of a party who engaged him. It is something which is natural. So that's why when you are doing the cross-examination, you must keep in mind, and whenever you find that there is some disconnectivity between the opinion and the reasons, so you can always give him a suggestion regarding the biasness. So you can always look for the material from where you can infer that there may be some ground, there are certain gaps which may be on account of biasness of an expert. So the best way is you need to do the cross-examination on merit, and once you get an answer in your favor, you can always connect it with the biasness. Now coming to the reliability of scientific evidence, right? So earlier we have discussed about the reliability of the scientific technology which are being used. Now we are talking about the reliability of scientific evidence, right? So when in particular evidence which is generated using the scientific analysis, so to what extent the court will rely upon that evidence. For example, if you talk about the video, and an expert has done some forensic examination using any tool, right? So what the court will look into. So it is a very important thing, and that's why I tell you that proving the forensic evidence is not something which is quite easy. It is normally being proved because either the party do not go into the cross examination, or the counsel which are doing the cross examination may not have the knowledge or about that particular field to do the appropriate cross examination. Otherwise, when we talk about the scientific evidence, it's very difficult to prove it. And there are three things which the court will look into. Number one, the validity of underlying scientific principle. So that is the Daubert principle which we have discussed. Second thing, validity of the technique applying the principle. So that means how you are applying it. For example, if you are applying it in the for using a tool, so then that tool need to be authenticated. That means, see, here the gap is that when you create a tool, that tool is created by a programmer, right? Who program and create a tool. But programmer can also make an error. And that is the reason which we have seen in the earlier case of that chloroform, that there were two tools showing the different outcome. So that means there is certain problem with that particular tools. So we also need to determine the authenticity of the tool. So how you will see the authenticity of the tool? Probably you may not have the source code, but the best way is that you must get the manual of that particular tool to see that how it is being functioned. From there you can get some idea. Or the other way is that you can use some other tool and to do the same analysis on your own or from some private forensic lab, and then you can confront the expert and challenge the validity of that. Third is the proper application of a technique on a particular occasion. So that I've already given you an example that if a video forensic has been done, right, but experts have not determined the frame rate per second or have not determined the resolution to connect it with the original mobile, so then they have not used the proper technique, right? Relevancy of the second opinion. So now, since in most of the cases of the computer forensic, we are finding that the tool is being used and two tools may give the different outcome. So now that challenge is being faced in the court, that the parties are calling for the second examination. And there may be number of reasons. First is one reason may be because of the different type of tool. Second is that the expert may also commit any error. He may be a biased one. And in such a case, parties who are on the opposite side or the judge on its own may not be able to find out what is the gap, what is the flaw, what is the fault with the forensic opinion. And the only option which they have to counter is to do to take a second opinion. And now in one of the recent case involving the mobile forensic, the Supreme Court in the matter of the P. Gopalakrishnan, where one forensic was done by the prosecution and the opposite party had challenged. The Supreme Court molded the relief and given the opportunity to the opposite side that now you go to the court and you get it forensic done again on the points which goes into your favor. So that is a very important judgment which now gives you a right to file an application where you think that the forensic has not been done proper or it is a biased or the methodology which is adopted by the expert is one-sided. So that's a beautiful judgment, one of the recent judgment of the Supreme Court in case of P. Gopalakrishnan versus State of Kerala. So now summarizing the things, one is the admissibility. For admissibility, the court will look into the competence. So first, your cross-examination should be on the educational qualification, experience, and how he has conducted the test, how he is able to connect the ground with the conclusion. Admissibility of the technique, so that we have discussed about the Daubert principle. Now authenticity, the court will look into the credibility of the expert witness, quality of opinion. So quality of opinion means how the results have been connected to the ground final outcome, basically the opinion, and opinion which is so. Third, SOP, whether there is an SOP or not, whether it is up to date or not. production of the reports, the test result, whether he says it, if he has done some test, expert says that he has conducted some test using the MKs or FTK or any other tool. So whether the output of that tool is available or not, then the court will look into expert evidence versus the eyewitness. So there will be other evidences also relating to the same fact coming from eyewitnesses or from other sources. Then ultimately the court will look for the purpose of determining the reliability of that particular entire forensic opinion, whether it is corroborated by the other evidences or whether it is contradicted by the other evidences. And then the court will evaluate them, appreciate them in totality, and ultimately will held whether such particular opinion is reliable or not. Now, one of the big challenge which comes with the computer forensic report is the white coat effect. So, what is the white coat effect? The white coat effect is, so I give you an example. It's a very important principle, and we have found that it is correct in few cases. So, I give you an example. A video have been filed by the prosecution which shows that a murder have been done by a particular person, and that video contains the that particular scene where a person is committing a murder. Now, this is the evidence before the court. Now, the issue is that when such type of evidence is there and it is also authenticated by the forensic expert, can the opposite party, by any type of evidence, can rebut it, can prejudice the court that it is not correct, he has not done the murder? So, answer is no. Because by other type of evidences, by traditional evidence, you cannot rebut it. Now, take the situation. If such video is forged, so that means accused would not have any mean to defend or rebut that evidence, and he would be only convicted. So in one of our case, we have seen the same situation. So the case was of corruption, and one of the sub-inspector had demanded the bribe. So the case of the prosecution is he has demanded the bribe on telephone, on mobile, and that call was recorded by the complainant, and that recording was in a memory card. So now that memory card was sent to the forensic lab. Forensic lab has given the opinion on two aspects. Number one, the voice matches. Number two was that authenticity of that particular voice file. During trial, when we were going to do the cross-examination, we find a very interesting thing. And the thing was, that particular voice file is in a MP3 format. And when we looked into that mobile forensic report, in the mobile there was no software which can create any file in MP3 format. Now the question is, which we put to the expert and also which we convinced to the court that there is no software by which MP3 file can be created. So now the question is how that file has come into that memory card. It cannot come. And the only probable way how it has come is, normally what happens when the people creates any audio or video file in a mobile, one of the big challenge or the limitation which they face is the memory space. And normally they transfer it to another media, either into their computer or in DVD or in some external media. But when they go to the police, when they go to the court, the first thing they encounter is whether that particular evidence is into the original device or not. So what they do? They put it back. And putting any file in the back in a memory card is something which is like a child play. And that was the case. So now you consider that this white coat effect. If that forensic report would have been accepted on the face of it, which in fact was an incorrect report, because expert does not analyze that this particular mobile does not have any tool to create MP3 file, then how that particular voice file has been created. And even the opposite counsel may not be in a position to find, even the court may not be in a position to find. Fortunately, because I was having experience into that domain, the person has come to me, I was able to detect it, and I was able to help him and protect him from the frivolous prosecutions. Otherwise, he would have been convicted on. So with this, I'm closing this session. And if there are certain questions from our participants, we can take. So participant can unmute themselves and they can raise their question. Anyone having any question, you can unmute yourself and you can put your question. Yes, Vijay Kumar, please tell me. ये हाथ ही खड़ा कर रहा है. Vijay, you can unmute yourself and ask the question.
Sorry. Good evening, sir.
Yeah, very good.
Just I have to clear about the definition about the experts. You have told that he should have qualification in the concerned field. My concern is whether only the qualification makes anyone expert.
No.
My concern is that I am from the police field and I am serving in the cyber cell or any other field, just like as you mentioned the CCTV. I am looking after all these systems since long, from 30 years, and I have the practical knowledge about that. But I don't have the educational or any higher qualification specific in the field. As a qualification means as a certified certification. Sir.
See, the problem here is that court does not personally know you. When the court will look into your testimony, the court will apply the test which is already been laid down by the Supreme Court in number of cases. So the requirement is what is the educational background, what is the relevant experience, whether you are able to explain the reason with the opinion, how you have conducted the analysis, whether you have the knowledge about the technology. Now, these are some of the parameters. So again, you may say that everything is fine with you because you are saying you are having a relevant experience so much about the CCTV and you are involved into for last 30 years. Court may agree with you, but again, it depends on if the opposite party do the cross examination and to what extent you are able to explain their answer. So it is something which is the contextual, so it will vary from case to case. So if you are able to show to the court that you are working on these issues for the last 30 years and you are very well aware, and if the court asks you something, you are able to explain, certainly you can convince the court that you have the relevant experience. And if you also have the basic qualification in the technology, so then see, there is one thing. You may not have the exact qualification on CCTV, but if you have the some basic qualification in the relating to the technology, and then you have a sufficient exposure over a period of time, certainly that would always be a relevant factor for the court to decide whether you are an expert.
Means honorable court is the final authority to conclude whether the person is expert or not.
Yes, they will look with some of the parameters which I have discussed.
Okay, sir. Thank you.
So anyone else? So on the next Saturday, we will be meeting again, and we can now a session on admissibility of the CCTV evidence. But I should relating to the CCTV evidence.
Good evening, sir.
Yes, sir.
So thank you very much for the very informative session. My query is regarding the biasness of the experts, sir. As you mentioned rightly that if one party is calling the expert, then there are chances that the expert may be biased. So is it by default we will consider that the party has called the expert, so he must be biased, or we have to prove again on a technical basis that the party has called the expert and he is biased because of the following reasons?
See, I have also explained that point earlier also, that we have to establish that point by during our cross examination by finding the gaps. For example, if the opinion is very good and the expert is able to explain all the things and also able to support his opinion by giving the proper reason, and also the ground for the reason, then even you may not be able to prove the biasness despite the fact that the party will engage in. So biasness may be there. Certainly, it may be in the mind. It may be something which may be inherent when a particular person is taking the money from a particular client to give the opinion. But certainly, if his approach is unbiased, he has done the forensic in an objective manner and he is able to conclude his opinion with a sound reason and he can explain it before the court, then you cannot prove the bias.
Right, sir. Thank you.
Okay, right. Thanks to all of you. So now we will meet next week, I think around the same time. Right? Thank you. Thank you very much.